Welcome to Criminal Justice 531. I'm Dr. Wiecko. During the next 5 weeks, we will be exploring many issues within criminal law and criminal procedure. This course is intended to give you an overview into criminal law and procedure, as well as make you aware of the various developments in state courts, as well as the United States Supreme Court. We will spend a significant amount of time over the next 5 weeks perusing the research literature in this particular area of study. Your book is an excellent resource, and you will cover it almost in all of its entirety. However, you are also given supplemental material, lecture material, as well as other books and readings that you will read throughout the semester. Before you proceed any further, you should read chapters 1 and 2 of your book, as well as the preface. These chapters, as well as the preface, describe the text-based method for this textbook, as well as familiarize you with how laws and rules are created and changed throughout time. Chapters 3 through 7 cover searches and seizures. You will notice that this is an area of criminal law and procedure that probably takes up the most amount of research space and time in your text. In fact, several chapters are dedicated to this. Probably as a result of both the disproportionate number of these cases as well as their impact on individuals' life, this is one of the most controversial areas of criminal law, procedure, as well as, quote, criminal procedure. You will find that most of these cases deal with the Fourth Amendment. Specifically, we have to find out what exactly constitutes a search and a seizure and when the government has in fact committed a search and a seizure. This is where the laws of criminal procedure start to attach. As you read this chapter, pay special attention to cases of Bostic versus Florida as well as Illinois versus Caballes. Chapter 4 describes specifically what happens when a police officer has reasonable suspicion. After all, suspicion in itself is not enough to make a stop and a frisk. Reasonable suspicion, however, is. The entire chapter deals primarily with what constitutes reasonable suspicion and when an officer may proceed on to stop and frisk an individual. Cases such as Minnesota versus Dickerson, as well as U.S. versus Brignani-Ponce, bring up several of the controversies that exist in this area of study. Chapter 5 deals specifically with arrests, which is a Fourth Amendment search and seizure that involves the taking of a person into custody. Mere detention of a suspect does not constitute arrest. Particularly, you have to pay attention to what constitutes an arrest and at what point do rights of criminal procedure attach. Specifically, the question to ask is when does a search and a seizure turn into an arrest? As you read, pay special attention to the Hedgepath case as well as Washington versus the Transit Authority cases described in your book. Chapter 6 deals with searches and seizures as well as searches with and without warrants. You will notice that there are several exceptions carved out for where warrantless searches are justified. However, this is a very controversial issue. You will see in your readings as well as in your additional materials that there is quite a substantial amount of research in this area. Finally, we will wrap up our discussion with special needs searches. These are particularly controversial and contain much less criminal and procedural law. These searches include inventory searches of vehicles as well as other property, searches of dorms and schools, as well as drug testing. As you read these chapters and your readings, pay special attention to Safford versus School District versus Reading.